versus Javar Tyrone Grayson. Case number SP 146436761, SP 146409991, SP 1463900, counts 1, 2, and 3. State your name for the record.
Grayson
Bay. I'm sorry.
Thank you.
State your name for the record.
Grayson Bay.
All right. This is today is the date and time set for a jury trial. Ms. Schneider, can you put your appearance on the record, please?
Good morning, Your Honor. Alexis Schneider for the people, P80322. For the record, the issuing officer, Officer Ambrose, was present, although I released him.
Mr. Grayson Bay, we didn't conclude some of the. First of all, I want to get the record straight from yesterday. I did mention, and you did cite. Where's Mr. Grayson Bay's file? Yes, but I brought it back downstairs. Yes. I wanted to clear up something I said on the record as far as the case that you cited out of Alabama. That I was incorrect as far as the facts of that case.
Before we even step into this courtroom, you need to understand what kind of case you're about to watch. This is the final chapter in a bizarre legal saga involving a man named Grayson Bay and Judge Perkins. Throughout this case, Bay has leaned heavily into a set of beliefs commonly associated with so-called sovereign citizen arguments. The idea that normal laws don't apply to you if you simply declare yourself outside the system. But courts across the United States have repeatedly rejected those claims. And today we're about to see exactly what happens when those theories collide headfirst with reality inside a courtroom.
That was not the case where they were walking down the street and did not obtain the license to assemble. That was a case where he has another reverend organized a sit-in and at a restaurant, and they were ticketed. And the unfortunate part about it is, and that's just how our society is, and it was, and still is for the most part, is that this case had to go all the way to the United States Supreme Court for him to get justice on this case. But again, you're citing cases, sir, that you're not even reading.
At this point, the stage is set for what should have been a jury trial. But instead of a full courtroom battle with jurors weighing the evidence, the prosecution made a strategic decision. They dropped the remaining charges. That may sound like a win for the defendant at first glance, but in reality, it usually means the case is already strong enough on the charges that remain. Prosecutors sometimes do this to streamline the process and avoid unnecessary court time when the outcome is already fairly clear. What that means for Bay is simple. The focus shifts from proving guilt to determining consequences.
Fine you. That's something a lawyer would be can be brought up to the grievance commission on and potentially lose their license. All the cases in there, all the cases that you have cited are saying exactly the opposite of what you purport. Have you looked at any of them?
Yes, Your Honor.
And you read them? When did you do that last night?
I've been studying more science. My religion is more science. As you can see, if it looks like a duck, it acts like a duck, it tells you it's a duck, it's pretty much a duck. So I'm more science. So I've been studying both.
What the judge is doing here is something that's actually very important in the legal world: correcting the record. Judges and lawyers rely heavily on case law, previous court decisions that help guide how current cases should be interpreted. If a judge references a case incorrectly, even by accident, The proper thing to do is acknowledge the mistake and clarify the facts. And notice the contrast here. While the judge is openly correcting his own statement, he's also pointing out that the defendant cited legal cases that don't support his argument at all. This happens frequently in cases involving pseudo-legal theories.
And,
But you haven't been studying.
no disrespect to you, Your Honor. I just want to remain mute to the fact and acknowledge that my mother is here, the matriarch of my family. And so I just want to remain mute to this case in this matter. And the floor is yours. This is your courtroom. No disrespect. My mother is here.
No. Ma'am, can you stand up and state your name, please?
My name is Mary Grayson Hall.
Good morning, Ms. Grayson Hall. And it's nothing about, you can see it. I just wanted you to acknowledge, I do acknowledge the fact, and I appreciate the fact that you have support here. The court always recognizes that. That's why I asked you to stand up. But you want to remain mute now. But you didn't remain mute when you filed these pleadings. This is how you speak to the court, exactly the way you did. Now, maybe the form is not exactly the way the court kind of or the rules have to apply, but I understand you're in pro per and you might not know all of those rules. But when you start filing these documentations, you're speaking to the court and you're representing that this is the current state of the law as this is the current state of the law, and this stuff applies to your case, and I should be reading this stuff and be able to interpret what you're saying about your case through these cases. And when I read these cases, it says exactly the ones that I've read, and I've seen these cases filed before, it says exactly the opposite of what you're trying to say. Because what I understand you're trying to say is that you're trying to say that you don't need a valid driver's license to drive on the roads, you don't need proper registration on your vehicle, and you don't need proper insurance. And you're even going as far as saying that the police officers, and correct me if I'm wrong, that the police officers do not even have the authority to pull you over. Is that correct?
Again, Your Honor.
Now this moment highlights a recurring theme in many courtroom cases involving unconventional legal arguments. The defendant begins discussing personal beliefs, science, identity, and philosophical ideas. While those topics might be meaningful to him personally, courts operate under a very specific framework: statutes, case law, and constitutional interpretation. In other words, the courtroom isn't a debate stage for personal theories about how society should work. It's a place where existing laws are applied to specific facts. That's why the judge keeps bringing the conversation back to the same basic point.
No due respect to the court, my matriarch is here, and I gave you pretty much documents to read, and I'm standing on those documents, and I'm gonna remain mute. Thank you.
All right, so I've already found you guilty of the count of refusing to exhibit a driver's license, SP 1464091. I'm going to fine you on that case $240. I've already found you responsible on SP 1463901, expired plate. I'm going to fine you $145 on that. And I've already found you responsible on SP
At this point, the defendant decides to remain mute, which is essentially his way of saying he will not engage further in argument. On the surface, that might seem like a strategic move. After all, people do have the right to remain silent in legal proceedings. But here's the important detail the judge immediately points out. The defendant already spoke through his written filings. When someone submits legal documents to the court, those filings become part of the official record. They are essentially arguments presented in writing. So even if Bay chooses not to verbally debate the issue now, the judge still has every right and responsibility to examine those documents.
14639-003, insurance no proof, and I say guilty on SP 146409991, and that's a 240 for the insurance no proof. I'm going to fine you $195 on that. All right. As far as the other counts, I had the note. Well, you told me off the record that you're going to dismiss SP 146436761 and SP 14639-002. Is that correct?
That's correct, Your Honor.
So 145, 195, and $240, sir. When can you pay?
I will probably need, after the holidays, maybe 3 months. I might get something up for you.
Are you working?
I do carpentry.
Yeah, you do carpentry. Are you working?
Yes. Yeah, I have jobs lined up.
Okay, so why do we need so much time?
They lined up. They're not completed. They're just future jobs that I have lined up.
Now we move from the legal debate to the practical consequences. The judge begins issuing the fines tied to the charges Bay was found responsible for: refusing to show a license, driving without proof of insurance, and an expired plate. None of these are dramatic felony charges. They're common traffic-related violations. But they still carry financial penalties, and the court has to enforce them. What's interesting here is how the conversation shifts toward Bay's financial situation. Judges often ask about employment because they need to determine a reasonable time frame for paying fines.
So presently, you're not working.
Today, I'm not in court.
You got this play on words.
Yeah, I mean, traveling and
Is
driving.
this
Yeah, there beats the system. Play on word. I mean, it's the truth, though. I mean, I got to speak the truth to you, right?
You're
You respect
not
the truth?
working now. If you,
Okay, I'm not working today. I'm not working.
No. You're not. I'm asking you, why is it taking you 3
We-
months to get up? I don't typically give out 3 months to pay fines, especially when somebody's working, and especially in a career that's a skilled trade, that's a very lucrative career. So I'm trying to give you the time you need, but I need to make a good basis for that.
3 months.
Because you're not giving me a good basis for giving you 3 months, and you're telling me you're a carpenter and you're telling me you're working. Now, if you're telling me you're a carpenter and I'm not working currently, then that's something that I can go with. But you're telling me I'm just not working today.
Right.
I'm gonna go to work tomorrow.
Very
I'm going
optimistic,
to work
yeah.
tomorrow, and I'm
Very-
going to work the next day.
Yeah.
So I'm not giving you 3 months.
Very
for that.
optimistic. That's why I say, well, as this present, not, but yeah, tomorrow. I'm very optimistic about work. So yeah, yeah.
So you're not working.
today I'm not working. Tomorrow I'm going. I have.
Here the judge pushes further, trying to understand the situation. Courts frequently do this during sentencing because they want to ensure decisions are fair and based on accurate information. The judge asks direct questions about employment and future work prospects. But instead of clear answers, the conversation turns into a series of wordplay responses about working today, working tomorrow, and possible future opportunities. That kind of ambiguity can frustrate judges because they rely on straightforward information to make decisions.
Grass work tomorrow to do. There are schedules to do, and I do have a future as a job to have things to be done. But as you saying, as I'm working, I'm telling you the truth, not as now. No, if that clears, if that makes you feel comfortable, no, I'm not working.
I'm trying to ascertain.
No, I'm
what's
not
going
working.
on, sir.
I'm not working at this present moment. I'm not working.
And when you say you're working, you have some aspirations of working,
Yes.
like everybody does. We're
Yes.
looking for, well, not everybody, because not everybody is trying to work.
Right, exactly.
So
Yes.
you're not working now,
Right.
correct?
Thank you, Your Honor.
Let me ask you this, ma'am. Is this the kind of, I don't know, I want to make sure that you don't need any mental health services? Do you?
Are you questioning my mental?
You're giving me all of this
Speak the
stuff.
truth,
You're-
Your Honor.
you know, I
I'm gonna
don't,
speak the truth.
I don't feel you're speaking the truth to me.
I'm not working today at this present moment. I'm not working.
And you're not working, you don't have anything set for tomorrow,
No, I don't.
right?
Nope, I don't. I don't.
You don't,
I'm
do you
not
have
even
anything
working.
set for next
No.
week?
No, I'm just anticipating things. You're right. I don't.
Do you understand what I'm saying?
Exactly.
I'm just gonna get you out of here. I'm gonna give you, till March the 5th. You can either Zoom in or come in. I'm gonna give you till March the 5th to have the stuff paid off, all right?
Can I get a total of that?
And just like that, the case comes to a close. The judge issues the fines, sets a deadline for payment, and the courtroom moves on. What makes this case memorable isn't the size of the penalties. They're actually fairly typical for traffic-related violations. What stands out is the clash between two completely different views of the law. On one side, you have the court system, built on statutes, precedent, and constitutional interpretation. On the other, you have a defendant attempting to challenge that system using interpretations of legal concepts that courts have repeatedly rejected.